Good morning and welcome to the Aird Berlis webinar, Workplace Wellness and Mental Health, Emerging Issues and Effective Management. We'd like to welcome you all this morning, and with me are my colleagues Michael Horvat and Fiona Brown, and we're going to take you through today some of the issues that are that employers are facing with respect to mental health in the workplace. We did one of these webinars a couple of years back, and the demand for a repeat and kind of an expansion on it has been significant. And not so much because employers are not looking to accommodate employees with mental health issues, but because they want to do it effectively. And this can go into a much bigger discussion of wellness programs and mental health at the workplace. But we want to really give you a sense of what the issues are, how to manage them, and how to do it proactively and effectively. These really are liability issues, but they're also issues that make for a better workplace with a happier population of employees. So let's start by looking at our agenda, and then we'll take you through the presentation. The agenda is we're going to talk about accommodation. You've heard about accommodation before. We want to make sure that you understand the accommodation principle from a mental health perspective. We're going to look at discipline and accommodation generally. The accommodation of mental illness, it's different than somebody who has a back injury or carpal tunnel syndrome or can't, or has an ankle injury and can't come to work or needs accommodation. It's a very different animal we have to deal with, dealing with denial, constructive knowledge, and subjective fears in the workplace, and managing medical information, which in these situations is absolutely critical. If you don't do that right, you're going to have a problem, and you're going to have a problem not only with respect to how you accommodate the employee, but potential liability. So let's start off with Michael. He's going to take us through a little bit of a definition of mental illness. Michael?
Mental illness can take many forms. I mean, there's not a pigeonhole with respect to those issues, and it's not only related to the workplace, but it is the events that can take place in employees' personal lives that then manifest themselves in the workplace. So it can be both medical and environmental and historical with respect to their own personal histories. So we're talking about bipolar disorder, anxiety, alcoholism, stress, addiction, depression, schizophrenia, and OCD. All of these are elements that can come and go, although some of them manifest a lot longer. And some of them have viable treatments, and some are more of a management issue with respect to managing the symptoms and effects in the workplace. Yeah. And as we see, especially with successful programs such as Bell's Let's Talk, it's becoming top of mind both for employees and employers with respect to work-life balance, and quite frankly, being a bit more courageous in their ability to address and confront mental issues within themselves, and expecting those to be respected by their colleagues and employers. It is the leading cause now of disability in Canada. Quite frankly, as programs related to injuries in the workplace have improved, and thus we're getting less injuries in the workplace, we see now this be taking a greater portion of that. It's estimated that there's $20 billion in direct loss and indirect costs related to mental illness in the workplace, and at least 1 in 5 Canadians will be subject to some form of mental illness.
And Michael, you can see why this becomes actually for HR professionals somewhat by managing it properly. It almost becomes like a profit center. If you can actually reduce the amount of disability and time off as a result, you're actually putting money to the bottom line. So it makes sense to be proactive in this.
And the change in legislation is actually going to direct that kind of savings to the bottom line, because what the changes in the Workers' Compensation Act, the Workplace Safety and Insurance Act, which is in effect now as January 1, 2018, is that compensation can be afforded to employees as a result of losing time from work due to mental illness and to treatment for mental illness. In particular, with respect to what's been the indication that it's not just post-traumatic stress disorder that's related to a workplace event. This is the gas station attendant who gets held up in the middle of the night with a gun in his face. We're going to start seeing claims being made with respect to workplace harassment and bullying that are going to be respected by the Workers' Compensation Board and potentially compensable under the new regime, which is, again, of course, going to go right to the bottom line. Now, quite frankly, the exclusions that we're looking at are quite broad with respect to typical management situations. That is, it won't include, effects of demotions, transfers, discipline, and the like. But where it relates to stress, harassment, sexual harassment in the workplace, those could go right to the bottom line with respect to a workers' compensation claim in Ontario.
Fiona?
Thanks, Michael and Lorenzo. Mental health disabilities are protected under a number of statutes, including, for example, the Ontario Human Rights Code. The code protects against discrimination on the basis of mental disability as a disability in employment. The definition of disability under the code is broadly defined, and under the legislation it's also quite broadly interpreted. It will include an array of conditions, disabilities, and disorders. In addition, the code's definition of disability includes those conditions, disabilities, and disorders which are perceived as opposed to only being objectively verifiable. There is no list of which mental illnesses are disabilities and which are not. The symptoms of mental illness can range drastically and take on many different forms. Mental illness becomes disabling when it imposes recognizable limitations on one's participation in work and society. It's a highly fact-specific inquiry, and it will be determined on the basis of medical documentation. Mere personal characteristics or normal ailments will not typically be considered a mental illness. And forms of treatment, which can have side effects that impact an employee's disability to perform his or her duties, may also fall within the scope of that definition.
So if you look at this, what you're seeing is that the difficulty oftentimes with mental illness as a disability is because it's often unseen. So you have to understand that it's also a perception. An employee's perception can also be a disability, even if it's a subjective fear. And we're going to talk about that in a little bit. Michael's going to take us through a case which gives you a sense of exactly how these issues may work out in the legal sphere.
When you have situations of mental illness in the workplace and going through the process of accommodation, which we're going to go through today, there's a lot of items that have to be brought forward that are somewhat unique in respect of mental illness issues and the kind of disability that you're trying to address. Most importantly is the communication between the employer, the employee, and the employee's doctor. And that ability to communicate is a little bit, and quite a bit more freer in this context of mental illness, because you've got to be able to understand, to some degree, the doctor has to understand the workplace itself and the nature of the illness and how those two can correlate to give direction to the employer as to what opportunities of accommodation there are. And in Battaglia, in the Ottawa Catholic School Board, you had a situation in which there was a disconnect with respect to that communication piece. That is, the complainant was actually diagnosed with a unipolar depressive disorder and had a supported leave of absence. But what essentially happened was there was a breakdown with respect to the communication as between the employee's doctor and the workplace as to what was actually necessary for this individual to be accommodated. And one of the requests from the employer was to engage in independent medical assessment in order to resolve some of the confusion. That was rejected by the employee. The employee wanted only the communication to be as between the employee and the doctor. And the employer in this case actually had gone through the proper process with respect to considering alternatives. And it was upheld that the employer did attempt to accommodate to the point of undue hardship in this case, that there was a lack of adequacy of information coming from the employee, and most importantly the employee's doctor, in order to facilitate that accommodation in the workplace. So where the employee can reasonably be failed to have provided medical information, it's actually doing a disservice to the employee from the doctor's perspective or from the employer's perspective, because now they don't have the information to support the claim for disability and to process the accommodation efforts.
That's a really good point. We're going to talk about that a little later on in the webinar, about the importance of medical documentation, how to manage it, because that is the key to dealing with these situations. We're going to deal a little bit with disciplinary behavior and mental illness. We already have a couple of questions. You guys are right on the ball about this issue and the connection between how do you discipline somebody, or do you discipline somebody with a mental illness or a disability. Well, we've added this chart, and if you look at what the conduct is, the inappropriate behavior, if there is a causal connection with the mental illness, discipline is not appropriate. So remember this chart, put it up on your wall. And accommodation is required. If there is no causal connection between mental illness, then it is simply a regular discipline and possibly discharge. So you need to establish that connection in order to prove that it's not in any way related to a disability as protected under the Human Rights Code, for example. So you can't discipline somebody if they've got if their behavior is connected to a mental disability. Just like if somebody, for example, had a heart condition or was diagnosed with cancer, you wouldn't discipline them for absenteeism as a result of that condition. It's no different when it comes to mental disability, except it's harder to figure out where the parameters are. All right? What the law has now evolved to say is that you've got to take proactive steps to determine is there that causal connection between the misconduct and the disability. And remember that you can actually now be deemed to have constructive knowledge of an issue if you should have known. So it's not just whether you knew, it's whether you should have known given all the circumstances. All right? And if we look at disciplinary behavior and mental illness when it comes to early indicators, and this is where we get to constructive knowledge, what you'll see the courts and tribunals doing is saying, well, what did you see beforehand? Did you see an increase in absenteeism or changes in performance, aberrant behavior that might be out of character, or a sudden change in medical prognosis or treatment? When you see those things, there is now an obligation on an employer to say, hang on, something might be wrong here. We have a duty to inquire, not to kind of breach any privacy obligations, but to inquire and figure out if there are issues that you need to deal with. That is the issue of constructive knowledge. Fiona?
Thanks, Lorenzo. So exactly, a court will ask, should the employer have known that the employee was suffering from a mental health disability? In making this determination, a court will consider, did the employee previously self-disclose issues with alcohol, drugs, or a mental illness? Was there any medical information regarding mental health issues in the employee's personal file? Did the employee make any statements that, in context, would have disclosed a behavioral concern? Or did the employee's conduct lead to medical questions and inquiries? Where an employer does suspect a disability, further steps need to be pursued to confirm whether there really is, in fact, a disability, including employers should obtain medical information that details the condition and the associated limitations, restrictions, and precautions that the employee is subject to. And employers should seek indications as to the permanence of the disability and the prospect for improvement in the foreseeable future.
All right, and you'll see from the cases how this kind of plays out. Really, really important, though, you need to understand as an employer what any restrictions or accommodations are. If you don't have those, and the doctor doesn't have the job description, as Michael talked about earlier on, there is no possible way they can even give you a sense of what these restrictions are. So when we move to the point where you've confirmed that there's a disability, just like think about it as a physical disability, a bad back on a line, an employee who can't work at their workstation because they've got a bad back or it's not properly set up. Think of it that way. All right? Medical evidence is going to be your key to clearing out whether it's misconduct related to a disability or it's misconduct which is on its own and disciplinable conduct. That's the medical. You can't. An employee is not allowed to use that handicap as a shield, but if it's appropriate, right, then that medical information must be disclosed. And as we said before, you have to establish that link between the illness and the misconduct. And if you can't do that, then you're into the accommodation sphere, initially at least, not into the discipline. If you can, and there's no causal connection, we're into discipline. Michael, good case on CMA that might help us understand all this.
Yeah, there's a couple of cases we want to go through with respect to this connection and what it takes to make the connection. The first important connection that's demonstrated in the Canadian Mental Health Association and OPSU is that the employee themselves must make a claim that the mental illness was that was connected to the disciplinable event that occurred. And in this case, actually, the employee, the griever, was a unionized environment, actually admitted that her condition had no impact on her ability to perform her job. Now, she was suffered from epilepsy, but in fact had no epileptic seizures at the workplace, and none that the employer said that we wouldn't have accommodated in any event. So the fact that there were performance issues with respect to her duties was unrelated to the medical situation that she was suffering through, and therefore wasn't, as Lorenzo pointed out, a shield to be used in order to otherwise protect this individual from proper discipline. So the grievance was dismissed. The next case is sort of the famous case dealing with the connection, and I think actually this is a case that probably would be decided a bit differently nowadays, given sort of the turn in circumstance and the environment that we're currently in. But this is the Ontario Nurses Association and London Health Sciences case. So this is a nurse who for more than 2.5 years stole narcotics for her own personal use and falsified records for the attendance of patients. It was quite clear and documented that she was suffering from an addiction, but her employment was terminated nonetheless. It was a termination that everyone probably on this call would have made that call, because it was one that goes to the root of her obligations to the workplace and to the patients that she was caring for. Now, while the arbitrator acknowledged that the nurse's misconduct would warrant cause of termination for cause in any other circumstance, the issue that he felt had to be addressed was, how does the addiction play into this? And there's a couple of things that may modify the arbitrator's review or tribunal's review of this. It was a long period that this employee was doing this. No ill effects to any patients. No one else made any comment with respect to her poor performance, and she didn't otherwise slip up with respect to her performance on the job. However, because she suffered from an addiction, the arbitrator felt that there needed to be an accommodation process, and namely that the employer, that the hospital had to consider whether or not accommodation for undue hardship had been reached. And in the end, the decision was to reinstate the nurse on the basis that, quite frankly, no harm had been demonstrated to patients, and therefore there was a belief that that treatment was going to be effective. I think that this case would have been done differently in the current context, particularly as it relates to the workplace that was at issue here. That is, you have an addictive personality going back into the source and access to that addictive drug. And I think this is a case that may now, given the turn with respect to legalized marijuana and other issues in the workplace, would turn differently today.
Thanks. Fiona?
Thanks. So in this 2015 case, it involved a long-term employee with more than 30 years of service. The employee witnessed a suicide on the job, and in addition was also dealing with some other recent family tragedy. The employee, as a result of this, was diagnosed with post-traumatic stress disorder and a major depressive disorder. Shortly thereafter, the employee engaged in repeated and premeditated theft on the job over a lengthy period of time prior to being caught. As a result, the employer terminated the employee's employment. At arbitration, the employee was reinstated, so returned to the workplace, but without any back pay. Interestingly, in this case, a psychiatrist did not make any conclusive finding that the PTSD or the employee's depression would have manifested itself into the workplace theft. And that also, what was interesting was that the thefts occurred prior to the diagnosis, but after the traumatic events. So largely for these reasons, the court on appeal overturned the arbitrator's award and sent it back for reconsideration by another arbitrator.
So really good case, because, again, we'll go back to the causal link, the direct link between the mental illness and the misconduct. In the Bell Canada case, we see that that wasn't established. And because there was no medical evidence that established the connection between the behavioral effects and the mental illness, they could not sustain the arbitrator's award, which was to reinstate the employee. Now remember, in many arbitrations, that's the issue, is what does the medical say? Can you establish the medical? Can we show that? That's why the medical is important. But when we look at, and I agree with Michael about the nurse's case, particularly now with the obligation for safety and the health and both safety of other employees and other workers, like the hospital would say for a nurse, well, we're putting our her patient's safety at risk if she even has access to these narcotics, even if she hasn't, when we've caught her, displayed that addiction on the job. So those are issues which will all be litigated, I think continue to be litigated. So if we look at this within the concept now of accommodation, so remember, there's two elements about accommodation for an employer. There's procedural and there's substantive. Procedural is how you go through the process in finding accommodation. Substantive is how you effect that accommodation where appropriate. All right? The code says you have to, as an employer, accommodate to the point of undue hardship. And what does that mean? Well, it means, and you've seen these before, those are kind of the factors that a tribunal or a court will look at, or an arbitrator, in determining whether there's undue hardship. Remember that the big one, okay, is cost, but very difficult to prove cost for an employer, very, very high threshold. And the biggest one really is safety. All right, if you can prove that the accommodation cannot be safe, for example, bringing back an employee, even on medication, who may be a danger to themselves or the workplace, and many of you out there will know that's exactly a concern that you face sometimes, that will be the issue. So, we'll talk about how that medical information helps you get there. But there's a couple things you need to remember about accommodation. Number one, it's just not the employer's duty. All right, everybody, unions and employees, will throw it right back at the employer and raise their hands and say, you accommodate. Here's my problem, you accommodate. This is my disability, I got nothing else to say. That's not the way it works. All right, it's on the employer, it's on the employee, it's on the union, and I would say you add the doctor to that as well. The doctor must provide the information in a manner in which it can be applied to the job duties of the individual in order to determine what accommodation is appropriate. So employees have to identify the nature of the disability and their resulting restrictions. If they don't, and those restrictions aren't based on a relevant job duty assessment, that might not be appropriate in terms of what the employee needs to do. And they have to facilitate the implementation of a reasonable proposal. They don't get to always pick and choose exactly what job they want in an accommodation. Fiona?
Thanks, Lorenzo. So employers have to accommodate a disabled employee to the point of undue hardship. In doing so, employers should consider whether there are existing jobs that can be adjusted, modified, or adapted to enable the employee to continue his or her participation in the workplace. Accommodating an employee once the employee returns to work. So medical clearance is not going to be a magic bullet. Employers may be required to, in certain circumstances, and this will be a very fact-specific inquiry, bundle discrete duties from different jobs to create a new permanent position, as long as the duties are productive within the employer's business. Disabled employees do not have to be assigned, non-productive duties on a permanent basis. Employers are not required to search every nook and cranny in an effort to find a job that the employee just simply, likes better. In addition, employers, in the event they're unionized, need to consider the collective agreement. What does the collective agreement say about the accommodation process? Is there an explicit or an implied duty to accommodate? How are the seniority rights, if there are any, going to play into this assessment? And it's essential and required for the employer to engage the union. It's important to discuss the issue with the union prior to taking any steps.
And the law is really clear. Unions are also under an obligation to accommodate in the context of a collective agreement. So if a union says, well, we're not going to allow you to bump somebody else out of a shift where accommodation is required out of seniority, you can say, well, we think you should accommodate on the basis of that accommodation which is required, and have that discussion. All right. Seniority rights are acknowledged by arbitrators. They're not the be-all, end-all to a determination on accommodation, but they are certainly a discussion point. Michael?
So with respect to the duty to accommodate and undue hardship, there's still a lot of emphasis with respect to what is the obligation of the employer. By definition, it's undue hardship, which means that hardship is going to be an issue for employers that they're just going to have to accept, and will have to do this on a case-by-case basis. And that's what we see in the Faculty Association and Laurentian University case. So this is a really good case relative to not only just showing what the obligations of the employee and doctor are, but really what the obligations of the employer were with respect to accommodation. So this is an employee, a university professor, who was on this fourth sick leave due to bipolar disorder. They had attempted to come back to work, had tried, had been successful, then relapsed, and had various accommodations over the past 10 years. Ultimately, again, they proposed a graduated return to work, and the employer took a hard line and said, this has gone on for 10 years. The interruptions and absences are now affecting students. So the university took the position that that wasn't a productive response with respect to yet another accommodation effort, and a grievance was filed, largely on the basis that the medical situation had changed, the medical determination and prognosis had changed, and that this was again another attempt with respect to a graduated return to work to a full-time position. Ultimately, it was determined by the arbitrator that the grievance was upheld, and the union's proposal with respect to graduated return to work was determined to be reasonable. And it ordered the employer to implement that plan. That's an ability of the arbitrator. That is a power that the arbitrator has in this circumstances, and no different than the tribunal, the Human Rights Tribunal, if this was a non-unionized workplace, if that's where the complaint was held. Ultimately, however, the arbitrator acknowledged and said, listen, this is another transitional situation, and it can be resolved. If ultimately it becomes a permanent situation, then you start getting to the point of undue hardship, because now no longer is there going to be any change in the workplace. That's a key distinction, the difference between transitional and permanent. The test, while the wording doesn't change on undue hardship, that test does get more difficult for the employee to meet, and makes it a bit more easier for the employer to meet. That is, what then is the economically important and viable position that the employee can perform on a permanent basis. But make no mistake, arbitrators and tribunals will hold a high standard to employees. Sometimes you're going to have to try to implement. You might have to fail in order to demonstrate that you've met the point of undue hardship with respect to a graduated return to work. So you'll have to go through that process. You simply can't assume that the process is going to fail, and you may be in a situation to retry. It's not just 2 strikes, you're out. It may be 3, it may be 4. It'll depend on the workplace and on the nature of the mental illness.
And that's obviously a real frustration for employers who say that we brought somebody back in, they failed again. But you will see in the successful cases on behalf of employers that there often are these trial periods which have not been successful. There's been a reinstatement to work, another trial period that's not been successful, as Michael says. So creating that environment where you've got a situation where somebody cannot initially be successful doesn't necessarily mean you can just terminate them, either for frustration or otherwise. It creates an issue that you have to reassess. Oftentimes, though, it's the employee themselves that doesn't provide the information, and if that's the case, you have to go down that route to ensure that you get it. We'll talk about that in a bit. If we look at now accommodating mental illness specifically, we want to hit on 3 issues here. Denial, constructive knowledge, and subjective fears. And we've talked about these a little bit across the board. And here's a good quote from a human rights case a while back, which we still use. And this, if you look at from 1996, really you could foresee where the law was going. At the latter part of it, says psychiatric disabilities have many possible causes, sometimes physical, psychological, and sometimes social. Such illnesses are shameful, embarrassing, and as a result, they are very reticent to stand up for their rights or to protest when injustice has been done to them. What we're seeing now with the heightened attention to mental illness in the workplace, you're seeing that that's less the case, so they're self-disclosing, which then triggers an immediate requirement to accommodate. So, denial, we do know that there's still going to be elements of denial, and particularly when we have addiction issues. People who have addiction, both substance abuse and alcohol addiction, are very reticent to come forward until they hit rock bottom, and that's a pathology of the illness, actually, that they have to hit rock bottom, and that's why you don't get it right away. So denial is a very real part. So denial of the disability may not end your obligation to accommodate, all right? A relapse might, but it doesn't mean it always does, and that's what Michael was talking about earlier on, all right? You have to reassess. Constructive knowledge really is, and this is another quote, an observer need not be a psychologist or psychiatrist to realize that the employee was probably mentally disabled. A motorist need not be a mechanic to conclude that his or her car would benefit from a tune-up when it repeatedly stalls. in traffic. So some things are so obvious you don't need an expert to figure them out. Here's the problem with that, is that the constructive knowledge piece does really require an employer to figure out things that might be medically related without specific information from the employee. So it's a bit unfair for an arbitrator to say that, but that's the standard you're going to be held to. So you should probably get used to it. So when we look at constructive knowledge, we talked about this before, odd or unusual behavior. Is there? Have we heard anything about their conduct or what it might, or what the root cause might be? Have they requested a leave of absence? Look for aberrant behavior. A lot of the time, that will be your key. More on subjective fears, Michael.
This is an important distinction with respect to mental illness in the sense that when it comes to accommodation, what the employee is thinking is as important or more important than, say, the person on the street or the objective person. When you're dealing with accommodation of a physical restriction, oftentimes you'll get an ergonomist report or a workers' compensation report that says an individual suffering from this situation should be able to do this work. That is, that this type of restriction is common amongst anyone suffering from this injury, and therefore if this work can be done by that person, then every person suffering from that situation, physical restriction, should be able to do that work. That's distinct from a mental illness situation in which every employee has to be treated individually with respect to how they manifest their illness and how they manifest their accommodation in the workplace. And really what it is a respect situation. That is, the employer has to be respectful of that distinction and address it with the employee and the doctor as a result. So it cannot be, unfortunately, a one-size-fits-all approach. Or a situation in which, well, we had someone else who was suffering, for example, from bipolar disorder, and we didn't have to take these steps in the workplace. That's not the issue. The issue is with respect to that in particular individual. So when you're talking about underlying issues, the importance here is, has the employee actually disclosed those? Even before you get into situations of disclosure, and is there any indication that a request should have been made for disclosure, any concern, that duty of inquiry that Lorenzo was going through. You had a case in Belhumeur and Windsor Factor Supply where the individual was suffering from a mental disability. It was actually various ones, but none of those had been disclosed to the employer at the time of the investigation or at the time of the event, and there was no indication that any question should have been made with respect to those restrictions. Therefore, when the employer ultimately made the determination that termination was a proper response, the tribunal, or the Ontario Court of Appeal in that case, upheld that decision on the basis that, well, it wasn't in the employer's mind, they didn't know about this situation regarding mental illness, nor should they have known, nor there was any indication that there was any question to that. So if the employer is unaware of it, and that's in part because the subjective fears of the employee haven't been made aware, then they can act accordingly. It would be interesting to see what would happen if there was a causal connection between the actual events and the discipline and the mental illness, if we would have seen an accommodation discussion then, and we may very well see in that circumstances. But if the employer is unaware and shouldn't be aware, then their actions in that sense are not a breach of the code.
Fiona, take this through the Fair and Hamilton Wentworth. This was a very big case and a big award.
Yeah. So in this case, after receiving a medical report which indicated that the employee could function in a job as long as it did not entail any responsibility for health and safety issues, nor any duties which would leave the employee at risk for personal liability, the employer ended the accommodation process and terminated the employee's employment. The Human Rights Tribunal held that the employer discriminated against the employee on the basis of disability by failing in its duty to accommodate the applicant. The Human Rights Tribunal arrived at this decision largely because it held that the employer failed to offer the employee available alternative work. So in the end, the Human Rights Tribunal granted the largest award ever received in a Canadian human rights case. In particular, the tribunal awarded reinstatement, despite the fact that the employee had been away from the workplace for almost 10 years, due to the fact that litigation is quite commonly a very lengthy process, and also damages of more than $450,000, which represented full compensation for the entire period of unemployment, retroactive pension adjustments, as well as compensation for injury to dignity, feelings, and self-respect. So this case serves as, a strong warning for employers of how important it is to properly accommodate an employee.
I actually look at this case as well, and in some ways, the Hamilton Wentworth School Board did some things wrong, but in other ways you look at it and you say, well, I can kind of understand it in a way, because over 10 years there were battles over medical documentation. This was a fight from the beginning, and it went on and on and on. If I take you back a couple of slides, though, look at the reason why she was off, right? Did not entail responsibility for health and safety issues nor any duties which would leave her at risk for personal liability. So the employer is saying, well, if that's part of your job, how can we accommodate somebody who is afraid of these types of issues? It's impossible. We've reached the point of undue hardship. But because they didn't manage the process appropriately, that got them into trouble, and it got them big damages. So I can understand the basis for this, and I can also understand that frustration with subjective elements of a mental disability. For example, I had a client a number of years ago who said the employee required to change the shift because he felt specifically that there were people on his shift that were out to kill him. Now, we knew for a fact in an investigation that there was actually not even any comments made to him. But his subjective fear, because he had a mental disability, was that somebody was out to kill him. That required accommodation. And I know you guys are scratching your heads saying, how do we do this? Well, we do it through medical, but Michael's going to take you through another case first.
So in Matheson, this is a really good case with respect to, again, this disclosure of information. So in this case, and I don't think this is a unique one, that is that the employee was diagnosed with a brain tumor, and ultimately what happened was there was a change in the supervisory structure. This person got a new supervisor and really didn't get along with the new supervisor, and a harassment claim followed thereafter, and including a leave of absence. The employee only went to the family doctor, not a psychiatrist and not a specialist. And the doctor, as opposed to providing help with respect to accommodation and consideration of the process, really took the shortcut with respect to what we've seen in oftentimes, which is simply stating that if the stressor, that is the supervisor, was removed, then the employee would be capable of returning to work. Questions beyond whether or not the doctor has overstepped their bounds with respect to this kind of accommodation process, the employer still responded properly and said, okay, we've got two options. You can move to another building where there's no interaction with the supervisor, so you're not dealing with the stressor, or you can move into another department. You'll still be in the same location, but you'll no longer have a reporting connection to the supervisor, again, the stressor being removed. The employee refused to try either of these approaches and simply took either option as a demotion and did not return to work and filed a human rights complaint. The Commission dismissed the complaint, and that decision was held up by the court on appeal. The employer had conducted a proper process of accommodation and review. Even, my questioning as to whether that was appropriate or necessary given the kind of medical information and medical adjudication that was being done. Regardless, the employer did the process, provided options. Reasonable options is not a best choice. It's not a smorgasbord with respect to employee choice. And the fact that this was compounded by a lack of objective medical support, actually supporting the restriction that was being imposed, that is the removal of the employee-supervisor connection, ultimately led to a conclusion that the proper procedural and substantive approach had been concluded, and there was no breach.
So we're getting a lot of that now, where we're getting employees complaining for harassment issues, creating mental health and stress, and the proposed accommodation is to remove the boss, remove the supervisor, which is obviously a real issue for a lot of employers, and which is why we've got to be very careful about how we look at these issues. And so that's why I want to just talk quickly about managing the process. It's no different than anything else. Have your documentation. Make sure that you're vigilant in assessing it. Don't act too quickly. All right. If you see aberrant behavior or issues which are kind of impacting the workplace, and you may suspect a mental health issue, recognize them. Ask for medical. All right. Don't proceed to termination. Get some advice, and then we can start down the path of medical information, which is critical, as we've said, to this process. But if you look at we're going to talk about workplace violence. There's a case in the city of Kingston where Arbitrator Newman said, look, you're under an obligation way back as a result of the Bill 168 to ensure that your employees are protected from workplace violence and harassment. All right, that's an obligation at law. All right, so in Niagara Peninsula Energy, an employee gets suspended without pay because they were acting aggressively, and the employer said, we want you to go through a psychiatric assessment. The arbitrator said, step too far. We've got to balance privacy concerns, right? And there has to be reasonable and probable grounds to suspect an employee suffers from a mental illness. So now employers are saying, okay, wait a sec. We're supposed to have constructive knowledge, and when we have that constructive knowledge and we say do something about it, then we get into trouble too. The answer to that is yes. So that means that you have to manage even more carefully. And when you look at what the legislative amendments are, it shows why, because the duty is on you, but there's also concomitant obligations of privacy. Fiona?
Yeah, thanks, Lorenzo. So, pursuant to amendments to the Ontario Occupational Health and Safety Act, employers have a positive duty to prevent and manage violence and harassment in the workplace. So, employers are going to have to balance their obligation to accommodate an employee with a disability with their obligations under the Ontario Health and Safety Act, including the all-encompassing duty to take all reasonable precautions to protect the health and safety of workers, which is quite an onerous and broad obligation. There's also a potential for workers' compensation claims for mental illness suffered as a result of a workplace harassment or violence incident.
So when it comes to managing medical information, there's a duty upon the employer to obtain the medical information necessary to consider the disability and the restrictions in the accommodation process. There is a duty on the employee to obtain that information. There's a duty on the doctor to provide it and review what's necessary. And really there's a duty upon all parties to rectify issues with respect to unclear medical information. And the employer is not required to accept vague or inapplicable determinations or direction from a doctor simply because it's coming from a doctor. In these situations where that clarity is not being obtained, then particularly if it doesn't relate to the accommodation process and the job process, you can take steps at that point to consider an independent medical assessment, essentially to break the tie or resolve the ambiguity. And it's an obligation that we're seeing a bit more with respect to matters relating to mental illness, where there's going to be potentially discrepancy with respect to medical opinion on the ability to accommodate. So while an employer is not able to ask for and obtain a specific diagnosis, really with respect to mental illness, you're seeing a bit of a sliding scale. That is, you're getting closer to the disclosure of some diagnoses. For example, you can have disclosed to you that an employee is suffering from bipolar disorder. You don't need to know all the intricacies of the actual diagnosis itself, but the fact that the person is bipolar has itself elements that will assist with that person's accommodation. And you're entitled to sometimes understand the medical treatment that's going off in mental disorder situations, because the actual treatment can cause side effects, and you have to accommodate the potential side effects as well, for example, any drugs that are being taken. So ultimately, all this information puts an onus on the employer to then keep those issues confidential in accordance with the applicable privacy legislation. So you better have a process in place for only letting those people who need to know and have access. Fiona?
Thanks. So further to, Michael, what Michael was saying, there's a lot of questions that you can't ask. However, we've set out here some of the questions that employers may ask. So an employer may request information about the nature of the illness, a description of the illness, but not the actual diagnosis, whether the illness is permanent or temporary, the estimated time frame for improvement, if known, restrictions and limitations, possible alternative duties in as much detail as possible. When making this request, it makes sense for the employer to provide, a schedule of the employee's regular duties so that the doctor can meaningfully provide suggestions with respect to possible alternative duties. how the medical conclusion was reached. So, for example, this sort of requires the doctor to admit, if it's the case, that that his decision or determination is based purely on the employee's self-reports, and then the treatment and medication. Ultimately, the longer the leave and the more demanding of an accommodation, the more substantive information an employer will be entitled to. In addition, in certain circumstances, a second opinion may be requested if medical information remains unclear despite requests for clarification, and in certain very limited circumstances, a mandatory medical examination may be required if there are reasonable and probable grounds to believe there is a risk of harm.
So let's use a simple example. If somebody, for example, you have an employee who is on medication and is perfectly fine when they're on medication, but chooses to not use medication anymore, that might change it from an accommodation issue to a culpable issue, providing they don't say that the choice itself was impacted by a medical disability. So those are one of the things, but an employer is entitled to ensure that the workplace is safe. That's where we get to. Michael?
So quickly, with respect to Kaiser Aluminum, this is a neat little case dealing with the issue of disclosure of medical information and backing up what an employee is actually stating with respect to what they are self-diagnosis, or even if it's a situation in which the employee is saying they believe that this is occurring in the workplace or this is how they're responding in the workplace. In this case, the employer's response was simply to ask for further medical information to support the position that the employee was taking. And the employee took the unique position that that actual questioning itself was adding to her anxiety and therefore was improper. So you can't even ask for the information because your asking is making me uncomfortable. This was rejected by the arbitrator. The grievance was ultimately dismissed. There was a lot of problems with it. First off, the medical information was equivocal, and therefore the request for more information and clearer information was clearly above board. The information that was being provided did not indicate that the employee could not perform her duties. And when she indicated sort of a personal reflection with respect to what was happening in the workplace, self-diagnosis or her own stressors, unfortunately the doctor that couldn't provide any medical support for the actual phobia that she was relying upon. So with respect to the disclosure situation, the employer acted appropriately. And so, as we've indicated, where there's a request to clarify unclear medical information, that is something that the employer can ask for. But remember, do not correspond directly with respect to the employee's physician. That's a breach in privacy that should not be undertaken. You may have situations in which you can have a doctor-to-doctor consult as long as both parties have consented to that, so the employee's consent to that doctor-to-doctor consult has to be expressed. And the information, therefore, rests with the employer's doctor, which means you're going to, if you have your own doctor, which means that you're going to need the consent for that doctor from the employee to then disclose the information to you. The better approach always is to go through the employee and direct the employee as to the information that is necessary. This can take many forms. That is, you're writing a letter to the employee to say to the doctor, I need answers to the following questions. Here's the additional information I need. Here's the additional information I have with respect to job description. But it should be through the doctor. Ultimately, when it comes to a knowledge of restrictions, in particular, this may abut other statutory obligations that the employer has. So, for example, under Section 33 of the Occupational Health and Safety Act, which Lorenzo talked about previously, is that you need to disclose to certain other individuals information that's been that has been related to a medical diagnosis or a prognosis where it impacts that individual. For example, the employee with history of violent behavior may pose a risk to employees, and particular employees. Those employees have a right to know that under this legislation, so that disclosure would not be a breach of policy. In fact, it would be an obligation. So oftentimes when you get the information, you need to know what to do with it as well.
So the number of, just to close this up, and then we're going to take a couple of questions. We have a few minutes to go through questions, and there are many questions. But when we're looking at managing medical information, because for us, this is the whole deal with mental disabilities and accommodation. How do you manage the medical information? Because it is and the first thing is be clear, be confidential in your requests, try to foster mutual respect and understanding and trust. Be sensitive to relapse issues, of course, and be vigilant. But also, we should add, be patient. Because I think there is a tendency where there are disability issues from a mental perspective, from a mental health perspective, to say, didn't get that, they're gone. You're going to be held to a higher standard. And there is, and from my perspective, there is an intrinsic raising of the standard when it comes to mental health issues. Physical health issues can in many ways be objectively verified. I think now arbitrators, courts, and tribunals are looking at those as being easier, right? They're not, but they look at them that way. And something that deals with mental health is considered to be, I think, presumptively, and we see this in workers' comp legislation, which is now presuming post-traumatic stress in certain occupations. They're presumptively deemed to be acceptable and verifiable. Well, everybody out there knows that out of 100 people who are saying that they're stressed and they can't work or there's an issue, there's going to be a percentage, and it might be pretty high, of people who are actually not suffering from a disability, and a percentage of those who are. And how do you get through those? So when you're looking at this, get advice, form your documents properly, asking the right questions based on the right information, and do not shy away from saying we need to understand the accommodation process and what they need in order to accommodate properly. It's as simple as that. You have the right to ask for that information. Why? Because you're under an obligation at law to accommodate. You can't accommodate without information. So remember that. So that's the end of our formal presentation. We want to go through a couple of questions. Michael, is there something that...
Yeah, there's a couple of questions I want to address. One is, where the situation is where you've got an expectation or belief that the employee is suffering from a disability or an addiction situation, and you've pointed that to the employee, and the employee either refuses or is in denial or simply states that that's not the case. And therefore you don't have the information to act upon. The duty to inquire, you've satisfied that with respect to making the inquiry. What you have to do further is put the employee on notice that if they're not going to provide further information to you that's going to explain the conduct or what is happening, then as an employer you'll have to rely upon the information that you have before you. This is particular with respect to addiction issues. That is that ultimately, if they're not going to provide you with the information, then rely on the information that you have. That is, some disciplinary event has occurred, there's no exculpatory explanation, and therefore make your decision accordingly. That will not be a breach of either the code or the collective agreement, because you have no information contrary to what you're acting upon. Now, that doesn't mean that if after the event of termination the employee then comes forward and says, in fact, I am suffering from an addiction, that you may not have to reconsider your position with respect to returning that person to work, and what is the undue hardship from letting that person now go get treatment and return to work. That's still a hurdle you'll have to overcome, and it may not be overcome in each circumstance. That is, you may have to bring that person back to work, but at least you put yourself on the best footing. The other situation that comes up is what happens if the employee is absent and is getting insurance benefits, and there's a disconnect with respect to the receipt of information. Remember, as the employer, you have an independent right and obligation to communicate with the employee regarding their absence for accommodation purposes. That is, that you can request and continue to request, regardless of the length of the absence and regardless of the fact that an insurer has signed off for benefits, you still have a right to get an update with respect to their medical situation, their prognosis, return to work, and accommodation efforts. Make that inquiry directly of the employee to tell the doctor to disclose it to you. Again, it's the same process, but don't feel that you can be sidelined by the insurer. And in fact, if you get to a point of frustration of contract, you will have to have demonstrated that you made an independent assessment.
Yeah, that's a tough one, because oftentimes you'll get a refusal of coverage for short-term or long-term disability and say come back to work, and you get a medical note saying they're still suffering from stress or a disability, a mental health disability, and then they can't come back to work. That's why it's very important to get that kind of a secondary or that objective medical evidence. There's an interesting question here about what the employer's responsibilities are for helping or assisting an employee with PTSD return to work when the PTSD was caused by workplace bullying. So this happens quite a bit, believe it or not. Obviously, you do believe it because you asked the question. But really, what we see is you got to take this apart. So, was that particular malady caused by workplace bullying, and what is the nature of that bullying? How did it show itself? what are the issues, and, for example, are we going to take the position that that was actually caused by the supervisor or the boss? There might be post-traumatic stress disorder, but it may not be related to the boss. So you need medical to establish that. Well, what's the medical that you have? Well, it's going to say, the employee is going to say, my boss made me suffer from this. So then you have to look at what the conduct was, and was there an investigation or a review of what the conduct was. You have to put these all together to determine and separate whether that's even an issue which might be the cause that would require you to accommodate. Because you know what the accommodation request is. It's going to be to remove the supervisor or the boss. And employers are not going to generally do that. And then the case becomes, even if it is proven, how do you accommodate? If it's a smaller workplace, you can't make them work apart. Right? If you have multiple locations, that might be an option. It might be an option, for example, in this case, for a person to stay on a disability if they need to recover from that, given the presence in the workplace. But you need all that information to make that determination, right? And when you have a situation where and I'll give you an easier example, where you've got somebody who's returning to work who might have violent conduct, right? And there's another question about this. How do you deal with that? Because you're under an obligation to keep employees safe. You have somebody who might have demonstrated conduct which was aggressive towards other employees, but you've seen some of the cases we talked about. You can't just automatically assume. What you can do, though, is deal with that aggression from a disciplinary perspective first and ask the employee whether there's any medical that supports their behavior or their conduct. That's the onus on them to establish that then, not on you. And if they can't establish that, or they refuse to give medical information, don't trigger right away. Even if they're away, give them opportunities. Say, we need this, either return to work or we need this information to accommodate you. And if they don't do it, send that letter again. We're giving you another opportunity. Don't just trigger. That's going to get you into trouble. Get some advice and do it that way. All right? So maybe we take this chance for one final question. And there's a question about wellness programs and fiscal constraint of employers, particularly in the public sector. I actually am a big fan of wellness programs generally. I think that they're helpful. I think that we've just scratched the surface of wellness programs in the employment environment, which can really assist. And by wellness, I mean lots of things. I mean meditation and yoga and assistance to certain types of physiotherapy, mental health assistance, EAP through that process, a more holistic treatment of mental health illness in the workplace. I think what we're going to find is that the investment into mental health, and this is where it's going to grow, good employers are integrating this, and I don't mean that people who can't afford it aren't good employers. What I'm saying is big employers who can afford it are integrating this into their workplace to give that assistance and that service to the employees, and the statistics seem to prove that employees are happier, more effective, and don't stay off as work as much, right? So it really is a cost-benefit analysis, but if there's fiscal constraint and you can't afford it, there's no obligation to provide those wellness programs, but it's something that I think personally as a group here, we're looking into, and you may even see a webinar in the next couple of years on us and on just how we put all those programs together, because I really do think they're positive for employees and employers alike, and there's a real cost-benefit analysis. So that's our webinar for today. A lot of information. Thank you for hanging with us on this. A couple things I want to remind you of. We have our Partners in Prevention. We will be at the Partners in Prevention a conference on May 1st and 2nd. We encourage you to look that up. It's at the Convention Center at 6900 Airport Road in Mississauga, Ontario. We are giving away some passes for complimentary tickets, and we're going to pick those attendees today, amongst you many attendees today, to get those 4 complimentary tickets, and you will be advised. I also want to remind you that there will be an upcoming webinar on Tuesday, May the 8th. That's steeper fines and new reporting obligations for employers from a health and safety perspective. Health and safety is taking a prominent role in many workplaces, and this will be a very interesting, proactive, and practical webinar. So thank you again for attending, and we look forward to meeting you again soon. Take care.